This week looks at several major topics and their rather unique relationships to one another. This includes the war on terror, the war on drugs, police brutality, and international agreements about torture. The article assigned titled Why Respecting Physical Integrity Rights Reduces Terrorism by Walsh and Piazza addresses how a country's approach to human rights might affect terrorism. Some argue that human rights may have to be sacrificed in order to prevent terrorism, while others argue that abuses aggravate political grievances that contribute to terrorism. Monitoring and detention of suspects, police sweeps to catch suspects, affording suspects lawyers in public trials, freedom of assembly, and of the press are all areas of limiting government that are believed to allow terrorism to flourish. The implication is that states that protect human rights are more vulnerable to terrorist attacks, and this seems to be borne out by studies that find that democracies experience more terrorism, especially new democracies in states with constrained executives, which are more frequently targeted. The idea that abuse of human rights encourages terrorism is a different line of thought that is exposed in the winning the hearts and minds approach that was initiated by Gordon Brown and the British Labour Party. The authors focus on one subclass of human rights, that is, physical integrity rights, that protect individuals from extrajudicial murder, disappearance, torture, or political imprisonment by the authorities. They describe physical integrity rights as critical in that violations offend the most widely shared norms of appropriate government conduct. They argue that abuse of physical integrity rights increases terrorism through three mechanisms: by alienating the government from members of the population that could provide it with intelligence about terrorism groups, by causing conflicts with other political forces in the country, thereby damaging the efficacy of government counterterrorism policy, and by reducing international willingness to cooperate with the government. They subject their hypotheses to a series of tests using a sample of 195 countries over a multi-year period. Although much research uses data only on transnational terrorism, they develop a new data set that also includes information on attacks by domestic terror groups. Their findings show that respect for physical integrity rights does substantially reduce terrorism. Their conclusion is consistent, even changing measures of terrorism with numerous control variables. Three bodies of work address the question of human rights and terrorism, finding different things. One group of authors looks at the relationship between political participation rights and terrorism, looking at civil liberties that permit freedom of expression, association, and personal autonomy, and seeing whether they reduce terrorism. Some find that they do reduce terrorism, while other authors find no relationship. These works differ from each other in their measurement of terrorist attack and time period analyzed. The current research addresses this by including a number of years, along with including domestic and transnational terror attacks. They also investigate the specific right of physical integrity, arguing that this is more closely tied to terrorism than civil rights and liberties and political participation. The next group of literature looks at democratic regimes and how they increase terrorism. Most of the findings indicate that freedom to publicize grievances, recruit members and supporters, and plan attacks, in other words, the elements of democracy that support democratic participation, are making terrorism more common in democracies. Other nuanced pieces within this group look at other mechanisms of democracies like constraint of the executive and democratic participation. Political groups are less likely to resort to terrorism when participation is greater because this allows them to redress their grievances through legitimate political channels. More constraints on the executive increase attacks by limiting the government's ability to take aggressive action against terrorist groups. Institutional checks keep a government from engaging in systematic human rights violations, and this in turn promotes terrorist activity. Walsh and Piazza argue that these studies have paid more attention to the relationship between institutions and terrorism rather than considering the role played by the behavior of the governments. This is important because democracies vary in their respect for human rights. A third body of work finds that abuses of integrity rights are significant predictors of dissent and insurgency, though sometimes in a curvilinear manner where states employing intermediate levels of repression experience the most violence. In general, the abuse of human rights increases the chances that opposition groups will turn into violent insurrectionaries. For example, Merriam argued in 2003 that more powerful democracies lose counterinsurgency campaigns when the educated middle class becomes alienated by the government's use of violence. This forces the government into crisis mode as it attempts to defeat militants and quell metropolitan dissent. Other work analyzes the relationship between dissent and repression. The most relevant research examines whether or not repression leads to more dissent or quiets it. There are conflicting findings in this literature, largely due to inconsistent operationalization of key concepts like dissent and repression. Governments violate physical integrity rights when they inflict arbitrary physical harm on individuals. Specific actions include extrajudicial killings, torture, disappearances, and political imprisonment. Keck and Sekink argue that norms about protecting the bodily integrity of members of vulnerable or innocent groups are among the most widely shared across cultures. The violation of these norms is interpreted by three major groups: the population, domestic political movements, and the international community. Violations offend at least some or all of these groups. The reduction of support for the government or behavior and actions that would otherwise hinder its counterterrorism efforts varies across these main groups. Widespread violations of physical integrity rights undermines legitimacy, making people less willing to support the authorities' counter-terror efforts and more likely to support those of the terrorists. Public support is critical to terrorist group survival. They start out with fewer political, economic, and military resources than the states they oppose, so they rely on political, financial, and logistical support from networks of non-combatant supporters drawn from the populations in which they operate or on whose behalf they claim to launch attacks. Terrorists plan attacks in ways that maximize popular and media attention, and violation of human rights by the state highlights these grievances. Abusing physical integrity rights drives at least some to support the terrorist cause and drives others to refrain from supporting the government. Some argue that because terrorists know this, they might act in ways to deliberately provoke such repression by the government. There is not much concrete evidence that points to this as a major motive, however. Counterterrorism is more effective and terrorist attacks are reduced when the government maintains its support among powerful political actors. Rival domestic political actors like political parties might intensify their opposition in response to physical integrity rights violations, and this type of political pressure may lead authorities to change policies midstream with the objective of dampening criticism, and this may also reduce effectiveness of counterterror efforts. Investigations into violations may lead to the deliberate or inadvertent publication of information that tips terrorists off about government strategies. Governments that resort to physical integrity violations when fighting terrorism risk losing international support. Terrorism is frequently transnational in nature, with terrorist groups crossing borders to commit attacks, attacking foreign targets, or fundraising, recruiting, and training and communicating across borders. Foreign governments thus might be very important to providing intelligence on activities of terrorist groups within their territory and use their law enforcement and security agencies to restrict the actions of these groups. Governments that attach importance to respect for human rights or are bound by human rights treaties may become less willing to provide support for the counterterrorism programs of states that violate human rights, fearing international as well as domestic consequences of collaborating with a notorious regime. A recent example pertains to European responses to U.S. black sites, where Europeans and Middle Easterners were tortured, inflaming human rights activists and public opinion in Europe. This led to German and Italian courts issuing warrants for the arrest of CIA personnel and suspending aircraft that were used for rendition. The Council of Europe issued a resolution demanding a review of all bilateral military basing agreements between the U.S. and the European Union. These authors measure their dependent variable, the incidence of terrorism, as the number of terrorist attacks recorded for each country in their data set for each year for which they are available. They draw from two sets of event data, Memorial Institute for the Prevention of Terrorism and the ITERAT data set. Their independent variables fall into three categories: government's respect for physical integrity rights, using SIRI measures that we've talked about before, measures of democracy using Polity 4, and the state's counterterrorism capacity. They also measure democracy. They also test other variables suggested by other authors like participatory rights and executive constraints. Table 1 shows their results. Physical integrity respect decreases the incidence of terrorism, while participation and executive constraints do not reach statistical significance in their multivariate regression. However, durability of regimes, which is their measure of the capacity of counterterrorism, increases attacks, as does population size. In Figure 1, we have an illustration of the four regression lines from the previous table, and they're illustrated in one graph. As they note, domestic attacks are the most impacted by human rights violations, and they experience the sharpest decline with increasing levels of respect for physical integrity. Their theory and findings differ from existing scholarly research on the causes of terrorism. Much of this work has drawn attention to the relationships between institutions of democratic governance and terrorism. Less attention has been paid to how the actual behavior of the government, such as its degree of respect for human rights, influences the incidence of terrorist attacks the state exposes itself to. The relationships between institutional measures of democratic rule and terrorism largely disappear when one considers government behavior in the form of respect for physical integrity rights. It appears then that how governments exercise their power, rather than how they are structured, is the decisive political factor determining a society's vulnerability to terrorism. The next two pieces for this week by Cooper and Ritchie and Mogul were written specifically about the United States. While police brutality encompasses more than the war on drugs, and physical integrity encompasses more than police brutality, this particular campaign of the war on drugs as well as the war on terror have created very strong intersections between policing and racism. And these articles give historic information about this policing of minority population. Ritchie and Mogul's report to the UN Committee on the Elimination of Racial Discrimination in 2007 addresses the history of racialized policing, reminding us that early police forces in the United States were created to be slave patrols. Racial profiling and police brutality have roots in slave codes, black codes, and Jim Crow segregation laws, facts that were addressed by the United Nations in 1951 when we charged genocide. A petition submitted to the Civil Rights Congress of the UN documented thousands of incidents of police violence against African Americans and Native Americans. Official studies have consistently found that people in communities of color are disproportionately subjected to human rights violations at the hands of law enforcement officers, ranging from verbal abuse and harassment, racial profiling, routine stops and frisk based solely on race or gender, to excessive force, unjustified shootings, and torture. Police brutality was highlighted again in the 1990s following the release of the videotape of the Rodney King beating by LA police. Since then, NGOs have reported widespread abuses by law enforcement agencies across the country. The UN Special Rapporteur on Contemporary Forms of Racism has stated that the excessive use of force by police against African Americans, Asian Americans, Arabs, and Indians has been cited as one of the most pressing human rights problems facing the United States. The U.S. Civil Rights Commission began in 1957. In 2000, it reviewed the findings of its 1981 report, Who is Guarding the Guardians?, a report on police practices, finding that many of the problems continue to be a problem today, with police brutality, harassment, and misconduct affecting people of color, women, and the poor the most. Shortly after the review, the U.S. War on Terror diverted public attention and discussion of accountability with regard to excessive force against people of color. Post 9/11 racial profiling and police attention has now extended to South Asian, Middle Eastern, and Muslim men and women. The Declaration of the World Conference Against Racism, Racial Discrimination, and Xenophobia argued that racially discriminatory conduct, policies, and practices substantially contribute to the persistent racial inequalities in the criminal justice system and in the incarcerated population. The report details the U.S. government's failure to comply with obligations under the Convention for the Elimination of Racial Discrimination, and it also discusses the obligations of the United States under the Convention Against Torture. In 2006, the Committee Against Torture expressed concern that reports of brutality and excessive force by law enforcement personnel in the United States were not adequately investigated. Later in the same year, the UN Human Rights Committee reiterated its concern about police brutality and excessive use of force. The United States has answered the report by acknowledging the existence of police brutality, but maintaining that its existing judicial remedies were sufficient to meet its obligations under the convention. But in reality, law officials enjoy impunity with respect to the excessive use of force. Criminal investigations are rarely convened, charges seldom brought, and convictions rarely brought or obtained. In addition, the feds are often unwilling or unable to bring federal criminal charges against law enforcement officers who engage in race-based policing and abuse. Police department disciplinary investigations are often conducted by the very same agencies employing offending officers or by civilian review agencies with little authority to discipline officers. Complaints of police misconduct remain private and confidential, and members of the public do not have access to this information. The authors argue that due to these facts, the United States has failed to satisfy its obligations under the Convention to prevent and severely punish and to take effective measures to prevent and eliminate racially discriminatory violence by law enforcement officials. Torture and other cruel, inhuman, and degrading treatment continue to take place during interrogations and in police custody within the United States. Law enforcement officers who have engaged in torture for the purpose of extracting confessions continue to escape prosecution. Coerced confessions continue to keep people in prison as well. The authors go on to document two egregious cases of police torture, including the Chicago police torture cases from 72 to 1991 and the San Francisco 8 cases in 1973. The authors also point to the fact that the UN Committee Against Torture has recognized that the use of tasers can amount to cruel, inhuman, and degrading treatment or punishment. Since 2001, more than 150 people, as of this writing, which was 5 years ago, have died after being shocked by police with tasers. Hundreds more instances of non-fatal cases of inappropriate and excessive taser use, some of them including unarmed children, have been documented. Today, we would add to those problems being investigated by the UN, tear gas and non-lethal bullets being used on people protesting against racism. People of color are reportedly disproportionately affected by police brutality, as are LGBT persons, especially those who are Black, Indigenous, or people of color. The problem of excessive force is exacerbated by law enforcement precincts' unwillingness to share and compile data on excessive force and brutality. There is no federal legislation binding on federal, state, and local law enforcement officers that monitors or prohibits racial profiling. Remedies for racial discrimination by law enforcement require proof of intent to discriminate and do not prevent or redress law enforcement practices that have racially discriminatory effects. The U.S. does not monitor or collect comprehensive data concerning racial discrimination of individuals stopped, searched, and arrested, but existing data demonstrates that ongoing profiling by law enforcement agencies is a problem. The article continues to demonstrate various types of racial profiling and how it affects women of color and then also immigrants, as well as other abuses like unlawful or abusive searches and sexual misconduct and rape. They also discuss police misconduct after Hurricanes Katrina and Rita. The article ends by making various recommendations for the U.S., who has failed to address the problems arising in its criminal justice system. They suggest enacting a federal crime of torture, taking immediate steps to document, systematically review, and prevent rape, sexual assault, and abuse. Also provide relief for torture victims, ban taser use, record complaints of all allegations of police abuse, and develop and mandate national training standards. Cooper's piece also outlines the historical narrative of racialized policing, pointing out that policing has been integral to maintaining the racial hierarchies, especially given that police forces were originally created to enforce them. The Black Codes were enforced by police officers after the Civil War. These were laws that made previously petty crimes into serious crimes when committed by Black adults and children, laws like loitering and breaking curfew. Police generated enough arrests for Black Codes that the number of inmates in Southern prisons skyrocketed, tripling in Mississippi in a 3-year span. The federal government dismantled these laws, but efforts to maintain racial hierarchies were reintroduced again with Jim Crow segregation laws. The war on drugs has had the effect of expanding police powers and playing into these racialized dynamics. First declared in 1973 by President Nixon, it is President Reagan who is credited with waging the full war, using increasing police spending and increasing penalties for drug offenses as the main weapons. Between 1982 and 2007, the number of arrests for possession tripled from 500,000 to 1.5 million, and they now constitute the largest category of arrests. By 1992, black people accounted for 40% of all drug-related arrests. In these years, blacks comprised about 12% of the population, while whites were about 82%. Research has shown that the use of illicit drugs does not vary significantly between white and black populations. Higher rates of arrest are correlated with higher concentrations of policing of black citizens. This article goes into detail about the United States legal code as well as the Supreme Court decisions that have tended to protect the power of police forces. The article also elucidates the Posse Comitatus Act, which makes it a felony for the armed forces to perform law enforcement duties of the civilian police. This act has been dismantled over the past 30 years to advance the war on drugs. The military has been permitted to give civilian police departments access to military bases, research, and equipment. The military also became empowered to train civilian police departments in using military equipment. Having declared drugs a national security threat, Reagan sanctioned greater collaboration between the military and the police. In 1994, the Department of Defense released a memorandum authorizing the large-scale transfer of military equipment and technology to police departments. These factors have been seen as hugely influential on the rates of police brutality as well as the rates of incarceration, and the United States has the highest percentage and the highest raw number of incarcerated persons in the world. The major points this week were related to the efforts of scholars to illustrate the connection between physical integrity rights and terrorism, arguing that reducing terrorism means greater liberty and freedom from policing and brutality, not more. At the same time, I presented a brief but troubling record of the United States policing regime as viewed from an international perspective. The war on terror has fit into the United States' preoccupation with security and law and order, but the implications for legitimacy, fighting terror, and police brutality are thrown into harsh relief by the evidence presented.